Hello, and welcome to the Utah Law Review Symposium on the law and ethics of medical research. Thanks to those of you who have already been enjoying our fantastic presentations and discussions over the last 2 Fridays, and certainly this morning when we were talking about COVID-19 vaccine trials. We now move to a panel that will build on the last panel, which brought up issues of intellectual property in medical research. And I now turn it over to our moderator for today, Professor George Contreras, who is a university scholar and professor of law at the University of Utah and the S.J. Quinney College of Law.
Well, thank you very much, Tammy, and to the Utah Law Review for organizing this conference and this panel. The 2 panels that we've already had in this conference have been extremely informative and valuable, and we hope to add yet another perspective to this complex discussion that's going on. Some may be wondering why talk about intellectual property in a conference that's devoted to issues of medical research and research ethics. And the reason that was forecast in the previous panel is that the COVID-19 pandemic has really caused a massive collision between what we consider to be the 2 dominant themes of intellectual property law. First, how can the government's grant of exclusive rights promote and incentivize innovation, the creation of new things like diagnostics, drugs, vaccines, equipment, algorithms, and systems to control and cure and contain the virus? And then the flip side of that question, which is what do we do when that same exclusivity limits access to these very life-saving technologies? It's a classic tension that we have in intellectual property law, and one that has manifested itself explicitly in the current pandemic. And so to help us think through some of these issues and many of the different angles that relate to it, we have 5 expert panelists who are going to speak with us. I'll introduce them each briefly, then each will spend 8 to 10 minutes giving us a little bit of an overview and an introduction, and then we'll have some questions, and are very happy to take your questions in the audience, which you should enter in text through the Q&A window. I'll also say before I introduce our panelists that this session is being recorded, I believe, and written proceedings will be produced and published in the Utah Law Review, along with a number of articles by our panelists and others, further elucidating the issues that we'll be talking about. So with that, let me introduce our panelists in the order in which we'll hear from them. First is Stephanie Plamondon Bair, who is an associate professor of law at the BYU School of Law. She is the recipient of a Ph.D. in neurobiology from the University of Utah, and we're very pleased to have her with us. Next will be Clark Asay, who is also a professor of law at the BYU School of Law. Next is Michael Eisen, who is a Howard Hughes investigator at University of California, Berkeley. And I would be remiss if I didn't say he is a world-renowned Drosophila geneticist, known far and wide. Next is Jenny Molloy, who is the founder and director of the Open Bioeconomy Lab at the University of Cambridge, and also part of the Department of Chemical Engineering and Biotechnology at Cambridge. And then Diane Peters, who is the general counsel and corporate secretary of Creative Commons, which is a widely used platform for sharing digital content, and who is also the steward of the Open COVID Pledge, which we'll hear quite a bit about during this session. So with that, I will turn it over to Stephanie, who will give us her introductory comments.
Thanks very much. Thanks to George for inviting us and for all the other organizers of the panel. So my remarks are going to deal with a project that's a collaboration between me and Clark, and so our comments are going to dovetail. And the project that we're working on is a project in which we've been exploring how adversity and challenge and crisis in its various forms might affect the motivation to innovate and innovative efforts for good or bad, and how that in turn might affect how we might want to structure intellectual property and other incentives for research that respond to challenges like COVID. So the project actually had its genesis in a previous project of mine where I looked at a particular form of adversity, long-term poverty, and how it affected individuals subjected to that adversity. And I argued that this type of adversity affected the brains of individuals in ways that negatively impacted their potential to innovate. And in discussions with Clark, he challenged me to think about instances where the opposite might be true, where there were some forms of adversity or challenge that might actually inspire or encourage people to innovate. Because anecdotally, it does seem like that is often the case, that adversity acts as a motivator for innovation. And as we were having these discussions, COVID happened, and we quickly saw how this area of study was relevant to the events that were happening around us. So we began looking into various literatures, including psychology, sociology, organizational behavior, neuroscience, to see if we could tease out any patterns about particular characteristics of adversity and what characteristics of adversity might either be conducive to innovation or, on the other hand, might stymie efforts to innovate. And I think we discovered some interesting things that can help explain what we've been seeing with innovation related to COVID, and also maybe give us some hints about how we might want to structure research incentives to deal with these types of challenging situations. So I'm going to talk about some of our findings, and then I'm going to hand it over to Clark to talk about some more of our findings, and then some of the policy implications that we've been discussing. So I think one of our most interesting findings from our research was that over a range of characteristics of adversity, including the duration of adversity, how long a particular adverse situation lasts, the breadth of adversity, how many life or organizational domains adversity affects, and the intensity of adversity, there was a U-shaped, or what we've been calling a Goldilocks relationship between that particular characteristic of adversity and potential for innovation. And so, in other words, adversity kind of had to hit the sweet spot of being not too much, but not too little, in order to be conducive and to inspire and motivate innovation. And the underlying reason for that is actually quite straightforward, because on the one hand, there's a lot of research suggesting that adversity can act as a psychological motivator. It motivates individuals to innovate in response to a challenge, to overcome the challenge, to overcome the negative feelings associated with the challenge. And on the firm level, adversity can create a market need that can be filled, and so can be motivating to firms in that sense too. But in order to provide this motivation, the adversity actually has to register as a challenge. It has to be long enough, intense enough, significant enough to actually create that psychological or market need and motivate an innovative response. On the other hand, it's also well known across a range of literatures that innovation takes resources. On the individual level, it takes cognitive and emotional resources. It also takes physical resources and social resources. So if adversity becomes so extreme in intensity or duration that it overwhelms these resources, then the potential for individuals and firms to respond to adversity with innovation correspondingly goes down. And I think we've seen this principle play out in terms of the medical research community's response to COVID. So COVID has definitely registered as a challenge worthy of response. And I think we've seen that in the mobilization of many firms and academic researchers to try to solve the problem. At the same time, although we might be tempted to classify the challenge as extreme, I think for purposes of the research that Clark and I have been looking at, it hasn't been so extreme that it has overwhelmed the capacity of universities and pharmaceutical companies to work on a solution in terms of their human resources and their financial resources. And of course, the influx of government incentives and cash hasn't hurt in that respect either, which is something that Clark will talk about a little bit later. So I'm now going to hand it over to Clark to talk about more of our findings and some of the policy implications of these findings.
Yeah, thanks, Stephanie, and thanks, George and University of Utah for having us here. In terms of like some of the other findings that we discuss in the paper, obviously these are broad trends, this Goldilocks principle that Stephanie mentions in terms of the intensity, the breadth, the depth, the nature of the adversity is neither sort of sufficient, right? Even if you hit the sweet spot, you might have a party that doesn't respond to the adversity in the way that we would predict. So these are generalizations. Obviously, the characteristics of individuals and organizations matters in terms of whether a particular party responds to the adversity in an innovative way. But the review of the literature, as Stephanie suggests that this Goldilocks principle is a pretty good indicator of whether, right, adversity is going to motivate or inhibit innovation. And so, like George said at the outset, the IP literature is really one of the key questions in it is, right, we want to provide parties incentives to innovate, and we do that in various forms: patents, copyrights, trade secret law, these different types of intellectual property law that we think without these rights in place, these incentives in place, parties may be more reluctant to pursue innovation. And so one of the things that we're trying to contribute here is that, and there's a rich literature about why that intellectual property rights may not be necessary in many cases to spur innovation. And so one of our contributions here is to say, well, there's this, adversity also can be innovation promoting and lead to innovation. And so this is just adverse conditions in general and can lead to innovation, but they can also inhibit innovation. And so we want to identify in this project, as Stephanie discussed, the types of adversity that are most likely conducive with or to lead to innovation. And so she's talked about that piece of it. And so then in the second half of the project, we looked at, well, so what does this mean about intellectual property? I mean, one implication is that when we have adverse conditions that are hitting the sweet spot in terms of promoting innovation, maybe it's best to pull back intellectual property protections. And the very straightforward reason, you can think about this in the context of COVID, is, right, we've got, as Stephanie mentions, this set of adverse conditions that have led lots of people, innovative people, to come together, work together to innovate for the benefit of society, find a vaccine, among other therapies. And so when we impose intellectual property rights in such scenarios, or grant intellectual property rights in such scenarios, the one effect can be less access, right? higher prices and so forth to the therapies and the vaccines, which sort of defeats the purpose of the innovation in many cases in general, because the less access you have, the fewer people that are being treated and getting the therapies and the vaccine in order to address the adversity that gave rise to the innovation. Now, you see just a few examples, and we discussed some of these in the paper. All of you can probably think of anecdotes of, perhaps from your personal life, once these adverse conditions with respect to COVID set in, lots of people coming together, sharing information, doing things that otherwise they might not do, right? And pursuing innovative activities to address concerns and problems that COVID has triggered. On the other hand, some of you are probably thinking, well, yeah, that only goes so far though, right? The pharmaceutical companies might not be willing to undertake, continue the innovative efforts with respect to vaccines and therapies and so forth without patent rights, right? And so part of what we explore here and what others have explored on this question is, well, yeah, patent rights is one way to further incentivize commercialization of the therapies and the vaccines, but you also have, as Stephanie mentioned, government grants, right? Funding, more direct funding, rather than leaving it to the market. We know what the adverse conditions are that we're trying to address. We don't need to leave it to the market. What we want to do is make sure that the innovation continues, and we can do that with direct funding and perhaps patent rights or market-based mechanisms such as patent rights are less ideal in such a scenario. Another thing we explore in terms, so one question is, in these types of adverse conditions that are likely to trigger innovation, maybe less IP is justified, and perhaps if we do need funding, more direct government funding is a better solution. Another question we address, though, is in some cases, we might need more IP, and that's perhaps in cases of innovation inhibiting adverse conditions. So we're out of the Goldilocks principle. We have sort of extreme conditions or unclear market opportunities that are still worthwhile pursuing, but there's just too much uncertainty, or the adversity is too intense, too long, too overwhelming. And so in such cases, we think of two possible solutions. One is just a greater commitment to funding for basic research, because there might be areas in the innovation ecosystem that are underexplored because they don't either present immediate commercial opportunities, or the adverse conditions are just simply not pushing innovators in that direction. And so in order to continue sort of the innovation ecosystem in addressing those and other sort of things that might go underexplored, greater commitment, recommitment to basic research, or funding for basic research. And then in other areas where market mechanisms might not sort of address needs because they're not big enough market opportunities, or they're just too great of uncertainty, we might consider sort of more exclusive rights in the form of IP to incentivize parties to pursue those solutions where adversity is not leading up society to pursue solutions in those domains. The last point that we make and that I'll mention is just this large area of technological path dependencies. So one implication of our study, I think, is that you have certain types of adversity that inspire innovation, certain types that inhibit it, and think about this in the context of COVID, right? If everybody's pursuing a vaccine, everybody's pursuing therapies, then other areas are being left unaddressed, right? And you have these path dependencies that develop in terms of where the avenues of innovation are going. And great, we're getting vaccines, we're getting different therapies, but it's probably could be done more efficiently. Now that's easy to say, and it's hard to say how we sort of fix that, but it is something that we want to highlight in terms of our project, that we do get these path dependencies, and we worry about those, and we're not sure how to fix them or how to address them. But IP rights can exacerbate those path dependencies. Patent racing, for instance, everybody's pursuing a vaccine rather than sort of worldwide global effort and coordination on a vaccine. Everybody's pursuing those on the basis of patent rights, patent racing, and that can be inefficient, and that can lead to sort of these rabbit holes and other areas that go unaddressed. So I will stop there and look forward to talking more about it.
Great, Clark, thank you very much. And thanks to both of you. And by the way, this paper will be one of the papers in the Law Review Symposium issue that gets produced after this. And so we're really looking forward to seeing it there. So with that, why don't I turn it over to Mike Eisen, who, as a researcher, was one of the people that Clark and Stephanie have been talking about. They're in the trenches, innovating, trying to innovate in the midst of this crisis. And what led Mike and others in that position to think about intellectual property, and eventually what became the Open COVID Pledge?
Right, thanks. It's a pleasure to be here, and thanks for having a non-lawyer in your midst. I've been a researcher for about 30 years, starting in graduate school, and over the course of my time at the bench and in the lab, we've gone from a world where patents were essentially invisible. I mean, we know they existed in biomedical research, but they I certainly didn't know about them when I was a graduate student. They were something that occasionally happened when somebody discovered a drug or something that had real obvious commercial value. But in terms of their day-to-day impact on biomedical research, they were just not present. And as I progressed in my career and postdoc and faculty, patents have become more and more and more a part of our day-to-day life as biomedical researchers. And I think that basically a day does not go by in the lab where we are not affected almost entirely in a negative way by intellectual property. I mean, we have every interaction we have with somebody outside of our institution has to go through some kind of material transfer agreement to protect each institution's rights to have power, and that takes time and effort and slows our ability to use new technologies and to apply ideas, things that are coming out of other research labs. It's not even talking about things that are coming out of companies. I have graduate students who spend a considerable amount of their time trying to come up with methods that work around existing patents, where there is technology that exists that came out of research labs, that exists in research labs, but because of the way it was licensed, it's not accessible to us in our labs, and so we can't achieve our research objectives because we have to deal with intellectual property. These kind of things, this doesn't even factor in the fact that almost everything we do is more expensive because there's this tax on both the legal side of it, but also things are more expensive because they come out of universities, go to companies, get licensed back to us at a premium. So basically, we live our daily lives as researchers impeded by intellectual property. And when COVID came along, I think the crisis and opportunity converged in a very nice way, as Stephanie and Clark just talked about, to incentivize researchers in academia to think about the ways that we could use our expertise and skills to deal with COVID. And I assumed that, we would go at this quest kind of doing what we sometimes do in the lab, which is just ignore IP and hope that things work out downstream. And I figured that would happen in COVID. So we had big meetings get together where scientists from all across the Berkeley campus sat in a room or Zoom room, and we started talking about things that we could do. And it was amazing to me that from the first moment we started having these meetings, there were discussions of patents. There were discussions of things that we couldn't do because they were patented. There were discussions of things where we didn't know if we could do them, if they were valid things that we could use to pursue strategies to deal with the pandemic because of patents. And even more astonishingly to me, there were already discussions about patenting the things that were going to happen in these COVID labs. I mean, I'm talking, February, day one in the biology response to this. And I felt like, well, if there was ever a moment in the kind of field where people would be able to see the destructive influence that patents are having on our research careers, and maybe also appreciate the ways that our own behavior were contributing to that problem by sort of always recasting everything that researchers are doing in patents. I mean, right? We've been trained over the last 30 years to start thinking about everything we do in the lab as being patentable. People write disclosures to our tech transfer office, even if you're just tweaking a method. And I think that this to me was a big problem from the sort of structure and construction of science. And you could easily see how this was going to be a problem in how we dealt with the pandemic. I mean, I think the vaccine companies are kind of navigating this in a reasonable way. I think we're unlikely to find that the vaccines are inaccessible or constrained by intellectual property. That is true, I think, because we're in the midst of this big pandemic. But dial back this crisis by an order of magnitude, and it's easy to see that how all this intellectual property stops us from developing cures, deploying cures in other contexts. And I think we really have to try to translate that into reality. And that's kind of what got me interested in trying to generalize the process of using this moment to both make sure that IP wasn't going to be an obstacle to what we were doing in the fight against COVID, but also I was hoping that it would serve as an instructive example for the community to try to change the way that we're dealing with things moving forward. And that you'll hear much more about what came of that from the other speakers.
Great. Well, Mike, thank you so much for that perspective. Now, obviously this is a pandemic. It's around the world. And so we thought it would be useful to hear from somebody across the pond. Jenny, who is at Cambridge University and in a slightly different discipline than Mike, as opposed to molecular biology. She is more involved on the engineering side of technology. But Jenny, we'd love for you to share your views with us.
Thank you very much. Yes, as you can see from the darkness outside, I'm based in the UK, just outside Cambridge. But I work very closely with collaborators in Africa and Latin America to develop manufacturing of basic research tools. There's a lot more, when you get down to it, basically we do engineer stuff, but we use molecular biology tools. So there's much more of a link between Mike and my work from a technical perspective than you might imagine. And that's a kind of the case in a lot of biology, that a lot of biology builds on a set of fundamental technologies. And many of those technologies are actually quite old now, in fact, over 20 years, which means that they have expired their patent protection. Of course, there are much better updates available and new applications that are being built on top of those. And so I wanted to pick up on Mike's kind of really kind of rich revealing of what it's like being inside an academic institution and sort of dealing with intellectual property as a barrier, to look at what happens when those innovations emerge from academia and try to get applied, particularly in an international context. So I think the first point is that most academics and developers of technology are not very well educated on how the patent system works. And so there's a lot of kind of misunderstandings, which actually unfortunately limit our use of open technologies, because, for example, many people don't quite, they sort of know that patents last for a limited period of time, but they may not know how long, and they certainly don't track the deadlines of when things expire. So part of my work is encouraging people to use what's already in the public domain through patent expiry, which is a fantastic resource. And also, like, patents have a wealth of information that often is not in the scientific literature. So I always encourage academics to kind of use that as a source of information. For those who've read scientific papers and the method sections, they can leave something to be desired. And one advantage of the patent system is that, in principle, there should be enough detail there for somebody skilled in the art to actually use the innovation. And so patents, although they can cause problems, as Mike has pointed out, the information that's embedded in them, and that kind of social contract of revealing as much as you can of what you know to the point that you can be granted a patent, can in some cases be beneficial. But a lot of the technologies that we're now looking at for diagnostics with COVID, some are over 20 years old, and some of that technology is now available. Some of it is new and still under patent. And I think the other kind of edges of the public domain that many researchers are unaware of is that, of course, patents are jurisdictional, and so they only apply in the places that you apply for them, and they can only be enforced in those places. And so for a lot of the colleagues that I'm working with in Africa, Latin America, and elsewhere, most often nobody has patented innovations there. But that doesn't necessarily mean that they are free to use them or have the kind of are empowered to use them through the knowledge of how to use them, accessibility of the know-how in order to use them, and the necessary international collaborations in many cases to make use of them. So although it's kind of good that many of the innovations that have come about through the COVID pandemic are in principle available to our colleagues in Latin America, Africa, and of course elsewhere around the world, that's just where I primarily work. It doesn't mean that they know that that the innovations are discoverable, or that there is freedom to operate for their partners and kind of other collaborators in this global effort. And so what I wanted to raise really is the importance of having very clear mechanisms for making it obvious and described and documented what somebody can do with a particular technology. That's super useful for researchers because they don't maybe know when they do have the ability to do things. So that's why licenses are really important, for example, for data and copyright licenses. And I think the same applies to technologies as well. I work a lot with people developing open hardware tools where they choose not to patent in most cases, but they also apply a specific license that tells people, yes, you can use this, yes, you can build on it, you can also commercialize it. And so being really explicit to avoid any fear, uncertainty, and doubt is one of the reasons we need innovative kind of initiatives that enable people to make that statement publicly. I think that around the kind of clarity and sort of knowing what you can do, there's also a lot of need to get those technologies transferred in terms of the know-how and the ability to use them. So I'm involved with an initiative from the United Nations called the Technology Access Partnership, and that's really about providing local production support and technology transfer facilitation, in my case for diagnostics production, but we have groups also working on PPE and medical devices. And so we do have a working group that look at technology licensing and how to deal when something is patented with the licensing of that. Just because something's patented doesn't mean it can't be shared pretty freely. You may choose to not enforce your patent. You may choose to have all sorts of systems in place for socially responsible licensing, for royalty-free licensing in developing countries, for example. There are lots of models, and so and often too many models for people to really decide how to structure stuff. And so many of the initiatives that I'm involved in have groups of people, lawyers and others, who are really looking at how to do that well and how to do it rapidly and urgently in the time of COVID. And so there's a lot of structures, and of course we're here to talk about one, which is the Open COVID Pledge. But just to say that, like, once the point of making intellectual property openly available, for even if it's for a certain period of time and even if it's for a particular use, that's only the first step in actually making it useful and having an impact. And so there's often much more to think about beyond that point. And fortunately, we are, as the Open COVID Pledge and kind of as a group of people on this panel, quite engaged with some of these efforts that are really taking the kind of other pieces that need to happen. And so another thing I just wanted to highlight in my section is that this is one piece in the puzzle. It's never going to be the sort of solving, getting the right IP strategy is never going to be the solution to getting those health technologies accessible and used and really saving lives. But certainly it's one of the pieces that we have to consider. And we're partnering with other groups that are thinking about all of those surrounding areas that need deep consideration as well. So I think that was really the main points I wanted to make. And I think we're now going to hear about the solution that came up. So all of the kind of problems and challenges that Mike and I have just outlined.
Yes, yeah, exactly. Well, Jenny, thank you so much for that perspective. And indeed, I'll now turn it over to Diane Peters, who can talk about this response that a number of us worked on together.
Thanks, George, and thanks to everybody at University of Utah for inviting me here. This is something that I am just so passionate about and love and breathe every single day, and live every day. So I'm excited to be here. So thank you. As I think about Open COVID and the pledge and Open COVID-19, from an intellectual property perspective, right, there are two extremes. One extreme is that I get to keep it all rights reserved, I'm not sharing anything. And then on the other extreme is everything has to be open. And so the solution that we came up with, which is just one myriad solution among many others, including the medicines patent pool and all of these other things, was why don't we, in response to really smart people like Jenny and Michael on this call, why don't we come up with something that is really simple and easy for companies to adopt, to signal that they're not going to get in your way regarding the intellectual property rights that they have. And that was really the founding moment for the Open COVID Pledge, which is really fun and exciting. So what is the pledge? I know that there are lawyers and law students on this call. So just to be clear, the pledge is a simple statement of commitment that an organization or holder of rights won't assert rights that they otherwise have against others. It's easy and simple and intentionally so, and internationally robust. We were overwhelmed. George will attest, Jenny will attest, and Michael will attest that when we published this thing, we actually did not realize that so many people, and I'm sorry to giggle, but seriously, we did not realize that so many people would come to the well and draw from this, this gift that we were putting out there. And so that was a completely overwhelming moment, but also just a validation on behalf of all of us. So that was exciting. So for many academics and law students at this conference, I think it's easy to think that the pledge is just a pledge, but it does include a couple of parts. So two big pieces. One is the pledge, which is a public statement of commitment. And the other is the license that underlies it. So we have all of these various licenses that we have 3 licenses in particular, and then we also have means for people to indicate that their licenses are compatible or they're an alternative license. And why is that important? Like, why does anybody care about compatibility and alternative licenses? It's important because at the end of the day, you as the researcher at the end of the pipeline wants to be able to use IP that someone else has produced, they've shared it, and you want to know that you can use it under basic terms that are consistent with our licenses or our principles. So so that's really important. To Mike and Jenny's and everybody else's concerns on this call around, like IP gets in the way, our licenses are completely intended to obviate that problem. So that's why we push for it. And so that is really exciting. I am really interested, George, and I know that we're up against time, but I'm really interested in talking a little bit more about, again, on the spectrum of, give it all up versus keep it all spectrum. there are lots of other solutions in there. The OCP was not intended to become like the one-stop, everyone should get on board with it. It's intended as an option, a voluntary option. And there are other options on that spectrum. For example, governments can, and there's big negotiations with under TRIPS with a lot of international organizations around forcing companies to relinquish their rights or allowing waivers under, governmental laws and similar. There's this whole spectrum. What the OCP is really a voluntary, legally very robust mechanism through the help of Professor Contreras and also Jenny and Michael and others who lent expert, on the ground advice, could we please do this and this? We constructed this idea of what it is to share, and it's an option. George, I'll pass it back to you, but I'm happy to share more.
Yeah, well, Diane, thank you. No, this is great. And thanks to all of you. And this really tees up a large number of issues and questions that are out there. And again, we're in the midst of this pandemic right now, kind of experimenting, if you will, with policy tools as we go along. And, 5 years from now, I'm sure this will all be written up and, the theories will be solidified. But they are sort of in the air right now. And so one question that might be worth discussing picks up on something that Diane mentioned, and really all of the panelists, can chime in on this if they want to. But what is the role for different policy makers here? The Open COVID Pledge is a private activity. 10 of us, individuals, academics, law professors, lawyers, got together in early March with the idea that this might be a good thing to do. And I have to thank Diane for being the one who brought me into this fascinating project. But there's a private effort, no certainty that that's going to come up. We usually look to governments, to intergovernmental organizations. Clark mentioned government interventions in some way. Jenny talked about UN efforts that are underway here. And what is the best way to accomplish the types of goals that we've been talking about? And obviously these can exist side by side, but what is the role for government here? Why did a private effort emerge here? Should a government have done this? Should the United Nations have done this earlier? What about more organized efforts? Is anybody, Stephanie?
Yeah, so one of the findings that Clark and I looked at when we were looking into this question was the fact that adversity on a psychological level, these types of challenges actually give rise not just to motivation to innovate, but also to a motivation to kind of collaborate and to work together and to share. And that's been written across in a number of domains, including, when disasters happen, you see this kind of almost spontaneous coming together. And so in light of that, I feel like the Open COVID Pledge in a way is not that surprising that that private actors decided to come together in this way. And because of that, you might almost argue that because of those individual motivations that arise through these challenges, you might not need government intervention because there is this private motivation to engage in these types of sharing behaviors. So that's one possibility.
Great.
I'll pitch in. I think that to be provocative, the problem is government intervention here. The government the government creates all this, funds all this research in the U.S. and decided to take that content out of that intellectual property out of the public ownership. So, we had to come together to do this. Not everything we were focusing on was government funded IP. In fact, a lot of it wasn't, but we have a problem in my mind because the government has empowered institutions that receive federal funding to turn that into private intellectual property, and they did so despite warnings that exactly this kind of situation would arise, where it became a obstacle to the scientific progress that it was supposed to be formulating. So, at the very least, I would hope that the government looks at this example and tries to alter the way that its funding is used to create private IP, such that it doesn't take a bunch of people, kind of coming together to try to overcome that on their own. This should be baked into the very way that government funding works, and that academic institutions who receive that funding turn their work into intellectual property. I mean, I favor a stronger view, which is that it should never happen in the first place, that federally funded work shouldn't be subject to private IP. But if you're going to do that, at the very least, we should come out of this appreciating that there's a need to have a system to exploit this in times of real national emergency.
Okay, Mike.
And if I could, do you mind, George? Can I jump in here quickly? So I just want to echo Mike and Stephanie's comments. I think that it is really important for us to think about a few things. So Mike touched on, but I just want to amplify that, tax dollars. I don't care if you're in Australia or in the European Union or in the United States, like tax dollars are going toward solutions to the pandemic. And I think that governments have to be accountable for what it is that they're funding. I do think that it's also important to think about, on the spectrum, I can't say, but I might suspect that some of the reasons people are attracted to the Open COVID pledge, among other solutions, is because they're terrified that the governments might come in and say, you know what, we're going to do something at a federal level in our country, and you will no longer, you have to give up your intellectual property rights over these solutions. So that is a wee bit of leverage for us as we think about solutions on a spectrum between, and again, it's a spectrum between, all rights reserved and, no rights reserved. And there's just a lot of mechanisms in between in this spectrum, George, that we should think about. And one that I know that companies are terrified of is that governments might act. And we all know that the WTO and others are talking about the TRIPS waiver in this day and age. And that's a scary thought. So I think that gives some leverage to encouraging companies to being a little more friendly with their IP rights. Just one more thought, because I may not have another chance to interject here, is this is just the COVID-19 crisis. We have the global climate crisis. We have like COVID-20 coming down the pipeline. We have a lot of crises coming down the pipeline. And I want to encourage this really smart room of people to think about what it is that we can do to encourage the responsible use of IP in the public interest and how that might play out longer term.
Yeah, absolutely. Diane, thank you. And I do want to come back to that question at the end. And we go till 11:45, so I think we'll have time to cover that. Hey, Clark, you had your hand up earlier.
Yeah, I was just going to, I think, try to add on to something Michael was saying about sort of the baseline where we set things, right? Like Bayh-Dole, this act that says government-funded research can be patented by universities. I think it is a real obstacle, and the private market can do a lot of things, but when you set the baseline and it becomes really entrenched, as Michael was talking about earlier, where So as you walk into the research with patents in mind, that not only affects the direction of research, right? Well, we won't do that research because it's maybe harder to patent or not patentable or whatever, but it also just affects the whole mindset of how these rights, whether they're to be deployed or how, like getting permissions and so forth. It just sort of, and this getting, I think, to Diane's point too, that there's a spectrum, and that university research that is the basis for so many innovations, it's often starting at that place of all rights reserved. And it's so sort of entrenched with the technology transactions offices, and sort of, we need to make money off this, even though they typically or often don't. And so I don't know what the solution is. I don't know if it's repeal of Bayh-Dole or changing it in some way, but I do think that it provides a real, that just the way that university ecosystem has developed in response to Bayh-Dole has led to really significant challenges for private actors, such as like the COVID pledge, to get over those obstacles and do things that are socially beneficial and useful to society at large. With respect to COVID, and like Diane said, with respect to other challenges that will arise in the future.
Great, thanks. And then Jenny, as the representative of the entire world east of the Rocky Mountains on this panel,
I just wanted to raise a couple of points, which I think one Clark kind of passed over, which is really important. He did mention it, which is kind of it's like the transaction costs and the sort of paperwork and involved. I mean, what you really need is clarity, and you need it quickly. And I think that's the overriding reason why we put the pledge in place. Because if you look at government action and how long it takes, so I'm going to get my dates wrong here, but I mean, we're talking February, March for the start of the pandemic, or really where we sort of saw it kicking off. The pledge was developed kind of pretty soon after that, and very rapidly, by a group of people that just did it, got some feedback and went forward. It was a couple of months after that Costa Rica raised the idea of a technology access pool. And sometime after that the COVID Technology Access Pool, CTAP, which is kind of led by WHO, was formed. And then now we're starting to see India and South Africa go into the World Trade Organization and sort of starting conversations around TRIPS in November. And so I think that, like, for me, the answer to your original question for me is just speed and agility, and that private mechanisms can do that in a way that governments just won't move that fast. And particularly, I mean, getting one government to move that fast is hard. Getting governments to move in unison for a global crisis is just even more difficult. So that's my contribution for the original question.
Wonderful. Thank you. Well, Jenny, you mentioned one government, and one government that is on many people's minds, at least on this side of the Atlantic, is the government that will come into office in January of this year. And there have been lots of conversations and discussion about what policies a new administration in the United States might want to implement for in a whole range of areas. But in this area, the intersection of intellectual property and innovation and COVID, does anybody have any thoughts about what you would recommend to the new administration in this area?
I mean, I think this.
Chime in.
Sorry, go ahead.
Oh, sorry, go ahead. Go ahead, Michael.
No, I think this, Bayh-Dole was recently, renewed with relatively little discussion about the impact it had on academia. And I think that it is time for a kind of comprehensive, analysis and conversation about whether the way that the government treats intellectual property it funds, and this is true for patents, is true for publications, it's the whole suite of things that the government funds, what is best for innovation, what is best for the goals of this funding. Bayh-Dole came out a long time ago. It was a very different context of research and information sharing. And I was surprised that it was renewed with relatively little discussion. I was sort of treated as a fait accompli. And I would love to see that conversation reopened, and at least use the COVID as an opportunity to really rethink the legislation that governs all this.
Great, thanks. Diane?
Yeah, Michael took the words right out of my mouth. But I also want to add or amplify that I think it's really important for us to think about, the government is not the only source of public funding. I think that one important place for us to push is with the foundations that have enormous, and sometimes more than the government could ever give, but enormous amounts of funding that they give to develop these vaccines and to innovate and similar. And their dollars are not dissimilar from the dollars that the federal government gives them. Foundations get their money tax-free. And so I think it's worthwhile to push it, not just from the government to foundations. And the other thing, I think Michael makes a really excellent point, which is in the European Union, for example, for anyone here from the EU, they do this annual or, semi-periodic reviews of, did the legislation do what we wanted it to do? So, for example, this year, we're going to talk about whether the database directive is useful or not. And that was passed way back when. And, it would be interesting to have a little bit of forensics around what it is that things like Bayh-Dole actually accomplished. And I think that if we could establish that, that would create a greater framework from which we could start to build on this idea that IP, there's a balance that needs to be discussed, and especially for IP and the public interest in times of crisis. That's all.
Thank you. Stephanie.
Yeah, so just to kind of, I guess, touch on points that others have made. I'm not going to come out strongly and necessarily in favor of repealing Bayh-Dole, but there is empirical research suggesting, looking at the effects of Bayh-Dole, and one of the effects of Bayh-Dole has been less of a sharing culture among academic researchers, which is something that both Michael and Clark have touched on. So to the extent that, we need an open COVID pledge to kind of counteract that, maybe we should think about, what is causing those problems in the first place. And then another possible consequence of Bayh-Dole. So as Clark mentioned earlier in his opening comments, we're kind of advocating for more of a focus on basic research, not just in a response to the current crisis, but as a way of laying the groundwork for the crises that Diane has mentioned are sure to come in the future. I think the more basic research we have, the better prepared we are going to be for those. And that's another consequence of Bayh-Dole, is that it tends to push research in the direction of immediately commercializable innovative solutions, and away from more basic research that doesn't necessarily have an immediate commercial exploitation. And so I think all of those ideas kind of point towards what Michael was suggesting, of kind of rethinking Bayh-Dole and what the effects of Bayh-Dole are.
Mm-hmm. Yeah, thank you. We have a question in the window that's addressed to Jenny, but I think if Jenny wants to take it, I think anybody else really can contribute to this as well. And the question is, what role do you see lawyers having in increasing clarity? Besides researchers, companies being open to sharing their innovations, what have you seen on the legal side of things that has encouraged the sharing of new technologies?
Yeah, so a couple of things in my space that have been really useful. And yeah, if you're a researcher and you want to share, you still have to figure out like how to do it and what's the appropriate license to apply and all this. And I mean, Michael and Diane can speak far more than I can to copyright licensing and Creative Commons and how that has played out in terms of open access and also data. But in the kind of technology side, there are other aspects. So if you have a patent, you can effectively choose how you make it available under a whole realm of licensing and different conditions, which is, as I mentioned before, quite confusing. And so there are now more legal tools, and they're constantly being developed that are very clear and how you apply them and what they're applied to. So for example, medical devices that were being innovated over the COVID pandemic by groups of volunteers, many ventilator projects, groups of academics came together to make oxygen concentrators, mask designs, other forms of PPE. A lot of ventilators are using open hardware licenses, and recently CERN released a whole additional, so there was a CERN open hardware license. It's now been expanded to a suite of 3 licenses to give more options. One's permissive, one's weakly reciprocal, one's strongly reciprocal. And so we're getting an increasing suite of open hardware licensing options that are kind of explained for the purposes of people that are developing hardware and want to decide how to make it available. Also from in my area of work, it's not just patents, but also material transfer agreements that can cause barriers and disruption and delays to research. And there is some empirical work and research on this. In some contexts, they don't seem to be a problem, but I think it really depends on what university you're at and how quickly your contracts office can deal with stuff. Certainly for a lot of my collaborators, particularly again, Latin American and African collaborators, it is a cause of delays. You need legal signatures and et cetera, et cetera. So myself and a colleague, Linda Kale, developed an open material transfer agreement that is a very simple document. It contains all of the no liability, no warranty statements that universities love, but it also has the fact very clearly stated in it that you can use this for commercial use and you can redistribute. And basically, because it's got in it that you can redistribute, once it kind of goes out of one institution, I mean, pretty much, unless the next institution decides it definitely wants to sign one, it's pretty much available to anybody. But it's clear, it says very specifically, so if you need a paper trail to say that you do not have any incumbent kind of material transfer agreements that stop you using this, it says that yes, you can use it for commercial use. And so again, maybe there was not, you could just transfer it without an agreement, but it's really helpful to have that clarity in a piece of paper that you can kind of take when you're doing your checks. So I'd say there are still there are constantly new legal tools being developed, and there's still a need. We don't have all of the options, and we certainly don't have options that are in some way standardized, that you can go to a website, see what it is, take it and apply it to your technology, and you do not have to have a consultation with a lawyer, which often for academics or kind of especially volunteer collaborators and developers, that we've seen over the COVID pandemic, that's not something that they really can do. And so these kind of off-the-shelf options, and I know probably lawyers are squirming in the room, the idea of sometimes these off-the-shelf options, because there are complexities, but they at least give you something to start with, and as long as they're well explained, they can be applied very appropriately in certain contexts. That would be my takeaway: is keep working with the tools because we still need them.
Just to add to that, I mean, the every time we have a license, even when we try to use open licenses, one of the challenges we have is our lawyers at the University of California have to modify them to make them, or say they have to modify them to make them compatible with California law and the law under which the University of California exists. And so an effort to, the stuff Jenny's done is amazing, because it really addresses exactly the problem, which is the material transfer agreements are problematic in the abstract, but they're really problematic in implementation and just the way that they slow everything down. And if the same kind of clarity could be brought to MTAs in terms of that Creative Commons licenses have bought to copyright sharing, it would just save, in terms of money and time, an astonishing amount in research.
Yeah, but we see the same problem. Most technology transfer offices don't want to adopt the standard protocol. They want to add their own clauses. And so even if you provide templates,
it's exactly what happens with us. So
I know for a fact that people from our general counsel's office are participating in this call, and so I'm glad they've heard your testimony. Clark, you had your hand up?
Yeah, I was just going to add to what's being said, is just and make just being aware of these tools, honestly. I mean, when you're advising clients and they may not know much about Creative Commons, or if they're software developers, open source software licensing. And so often when I worked at Amazon and at a private law firm before coming into academia. And one of the biggest problems was just a lack of, I mean, open source software, Creative Commons been around for a long time, but lawyers in general don't know a lot about these tools, unfortunately. And that's a big hang up too. That causes a lot of just slowing down of things internally at different organizations.
Great. Well, we have 5 minutes left. I thought I would turn back, unless anybody had anything else to add on that point. I thought I'd turn to the question that Diane kind of foreshadowed in her first comments, which is, well, what about the future? What have we learned from COVID-19 in terms of IP and innovation and their clash or their combination? And like, is this anything that we can apply in the next pandemic? I mean, there are any number of global crises, including, drought and storms, and most importantly, climate change. Have we learned our lesson? Will the next one be easier to deal with? Anybody? And well, people, Diane, since you raised that,
I'll share an initial thought, George. Thank you. My initial thought is that Jenny is involved with TAP. I'm involved with CTAP, and I think it's really important for us to force, as in truly force, these issues at an international level. So I would be happy to support any effort to make the WHO or WIPO, where none of this conversation is happening, by the way, like the World Intellectual Property Organization does not even have this on their radar screen yet, and we're a member of their SCCR and other committees. It would be great if more people could force these issues at the international arena level. That takes a lot of time, granted, but that's where basic infrastructure change takes place at a legal level. And so I would encourage that. And then also to be involved at your federal levels as well.
Great, thank you.
Yeah, I mean, one challenge is that we dealt with, and as you know, in dealing with institutions, the organizations, they were really eager to constrain the reach of these patents, right? They wanted a time constraint. They wanted it only to apply to COVID uses. They wanted only to apply to for a limited amount of time while the pandemic was still going. So I think, the more this becomes, the broader the scope of things that this applies to, the more pushback you're going to get from the intellectual property holders who will. So I think it doesn't naturally scale. I think there's something else has to happen to scale it. So, and I think the same pressure will exist. It's going to take this even bigger effort, even bigger pressure on people to apply to something. Climate change is going to, we're going to be fighting that for centuries. It applies to everything from food to energy. Like things like that, you could argue cover all intellectual property. And so trying to think about how we deal with those it's probably going to require, in my mind, it's going to require something more than just voluntary commitment from rights holders to let their IP be used for this. So.
Diane, did you want to make an intervention? Well, to Mike?
No, I'm jumping up and down and raising my thumbs and in complete support of what Michael has just said. I think that it's going to require a heck of a lot more. But this is a unique moment in our history. This is a unique moment where it's not, the flu epidemic of whatever in the early 1900s. It's not, we actually are in a modern age where we have our first serious global pandemic. And if we do not seize this opportunity to change the minds and directions, and to Jenny's questions, I don't want anyone like Jenny to ever have to ask permission to do anything with respect to any of her research. My goal, and I think all of our goals should be to make it as easy as possible for researchers to do what it is that they need to do. And again, we're at this unique inflection point. So if we don't take advantage of it now, when will we take advantage of it exactly? It's hard enough as it is. That's my only intervention, George.
Thank you. Any of our other panelists, such a last word?
I guess my last word is that, the nice thing about the Open COVID Pledge was that we put an option out there for people, which is not often on the table, to echo Clark's point like this, and Michael, I think, made the same point. There's not often, this is just not an option that is given to people. And some people took that option. And so I really hope that we see at least, we see some good impact from that, and we certainly don't see any harm from it, because I think that story of, these big organizations took a risk effectively in making their technologies available. It really helped. We saw some impact on the pandemic, and it did not really impact their bottom line. The sky didn't fall in, nothing majorly bad happened. I think that this is kind of opening the conversation. So I don't think we're fully prepared for another crisis or next time around, but I'm really hoping this is a precedent that is helpful in the future, because people tend to be risk averse in these spaces, and having precedent is really helpful as we move into those conversations when we have to tackle the next time around. So that would be my hope.
Well, and you see some parallels with open source software, right? Like when people first started doing it, other corporations and people thought they were crazy, and then 2 decades later, that's sort of how everyone does things. I mean, not everyone, but it's very well established as this is a really good way to sort of innovate. So hopefully that parallel would transfer over to other problems that we face in society.
Wonderful. Well, if that concludes, we are just a few minutes over time. So with that, I will conclude the panel, turn it back over to our organizer, Tammy Frisbee, who will perhaps give us some instructions for the rest of the day. But I really want to thank each and every one of our panelists for an engaging and really fascinating discussion. I appreciate it personally and look forward to continuing to work with you all as we, as we continue to muddle through this crisis. Thanks.
Thank you so much, Professor Contreras, and thank you to our panelists for such a lively and important conversation. Thank you for joining us from just down the road and from the other side of the world. Those of you who are joining us as attendees, thank you so much for your participation and engagement. We will now take a break for lunch, and we will reconvene at 1:00 p.m. Mountain Time for a conversation about medical research as a public health initiative, the fourth and final panel of the 2020 Utah Law Review Symposium. Thank you very much.